Hello everyone, Adi Simion, Coldwell Banker. Beautiful day in California. It's about 7 o'clock, nice and sunny. We had a little bit of rain for the past few days, and it's nice to see a clear sky today. Every morning I'm trying to think about issues that come up on the real estate transactions and give you a little bit of an advice on how to overcome them and don't make the same mistakes I did or other people did. Today I want to talk about the importance of knowing your offer and the contract to purchase. When you put an offer on a property, you have some contingencies that are protecting you. So that actually really are protecting your 3% deposit. Lately, well, just the other day I had a client call me. He put an offer with a different agent, and then he decided that he doesn't want the property anymore because there something came up at the inspection, and he was afraid that he's losing his deposit, his 3%. That could be a lot of money depending on purchase price. So he called me to ask me what his rights are. So obviously the agent that he was working with has not gone over the contract with him, hasn't explained him what the contingencies are, and that he has actually due diligence contingencies that protects him from losing the deposit. He puts the deposit in escrow when the offer is accepted, but then he has an amount of time, normally 10 to 17 days, to do his inspections, and if he doesn't want the property, he can cancel and get his deposit back. He was under the impression that he lost his deposit and there's nothing he can do. So I looked at his contract and I told him, yes, you are still protected, you can cancel, and it doesn't matter. You just decided that you don't want to move forward, you are within the time period, you can cancel, no problem. He was very excited and very thankful that I told him that. He believes that he got his deposit back when he the whole time had the right for it. So when you buy a property, you have first a contingency for documentation. The seller is required by law to answer a bunch of questions about the property, so you know what you're purchasing, defects and other matters of the property. Secondly, and that's a 7-day contingency, the seller has to give you that paperwork within 7 days of acceptance. If you get to look at that and you don't like something in there, you have the right to cancel, you get your money back. Second one, it's the right for inspection and due diligence. You have the right to go inspect the property, and if you find things that you don't like, you have the right to cancel, and that's normally by default on the contract 17 days. Then you have if you are buying with a loan, you have an appraisal contingency, that's normally also 17 days, that your bank will send an appraisal to the property, and if the property appraises for less than purchase price, you now have the right to negotiate the deal again or cancel. And then you have your loan contingency, which is normally 21 days. If within 21 days you apply for a loan and you get declined for some reason, you have the right to cancel. All these contingencies are protecting you automatically. You don't have to do anything, they protect you. They have a time frame, but if you do not remove those contingencies in writing, meaning the agent will come to you and say, now you have to remove your contingency in writing, sign this piece of paper. If you don't sign it, you are still protected, even though more days than the agreed upon days passed. But the downside of that, if you don't remove the contingency, the seller now has the right to give you a notice to perform, meaning he will tell you to remove that contingency in writing within 2 days, and if you don't, then the seller has the right to cancel the contract. If you remove your contingencies and then you change your mind and you said, oh, I changed my mind, I don't want to buy this property because whatever reason, but you remove that particular contingency. Let's give an example for inspection. You did your inspection, you did decide that you're going to move forward after that 10 or 17 days, and then you decide, well, I don't like the school district, I'm not going to go there anymore, I want to cancel. Well, now you may lose your deposit, but not even then. Then you go to mediation and arbitration, and you have to make a case. Actually, the seller has to make a case that they had damages by taking the property off the market. They lost out. They could have get out the buyers, and they lost time and whatever, and they can put a price on it and take some of your deposit up to the 3%. So even then, you still protected by going to mediation and arbitration. You go to mediation. If the mediator says whatever they say and you don't like, you can say, no, I don't agree with you. I still want to go to arbitration, which is a retired judge, and that's when you will be actually doing what the guy says. The reason for that is not to go through the court system, because it takes too long and you want to take your money back and move to the new property. The seller wants to take their property back on the market and sell it to somebody else. So that's why you use mediation arbitration. But know that the point I want to make is, when you put an offer, make sure the agent goes over the contract line by line, so you understand exactly what you're signing and what your rights and duties are, so you're not surprised and don't have to call other specialists later to get explained, because sometimes it could be too late and you can lose. That's all I had to say for this morning. Make sure you know your contract. Have a good day now. Bye.